We're here to discuss about two recent discussion papers. Both of them are dated 14th of June 2022 and are on the subjects of first is enabling IPEs to become IP, and the second is streamlining the liquidation process. So the subjects being very crucial for the way ahead for this new regime. I will not waste any time now, to take that to moderate the discussion, we have Mr. Ravi Prakash Ganti sir here with us. I will just take 2 to 3 minutes to briefly introduce her and then straight away request her to take over the discussion. So, sir is an insolvency professional, and sir is also a director at Resolve International Private Limited. Sir has held high and illustrious positions at several big organizations. Sir, for example, sir has been the director at Messrs. Aquarius Business Solutions Private Limited and also Universe India Limited. Prior to that, sir was the Deputy General Manager at SI Group India Limited and Senior Manager at Hyderabad Engineering Industries. In terms of qualifications, sir is an engineer from IIT Kharagpur. Sir is an MBA in Finance from XLRI Jamshedpur. And okay, sir is also pursuing LLB from Padma Shri D.Y. Patil College of Law. Sir has been an insolvency professional of repute and has already dealt with a lot of assignments and has simultaneously also advised a lot of IPs in their assignments. In terms of association with us, sir is our insolvency professional. Sir has also been our regular faculty at the PREC programs, the roundtable discussions, is also the workshops. So with that, I would request sir to start the session. Sir, over to you.
Thank you, Nitin. Okay, next time make the introduction just 30 seconds. Sure. Okay, welcome to all. Thank you for joining this roundtable. I think this will be the last one to be conducted on these two topics, because now the date has come for submission of the final suggestions. And what we will do is we will be covering two papers today. The first one, IPEs as IPs. That is relatively a shorter discussion because the issues are quite specific, 3 or 4 of them, which we will cover. Then we will follow it up with the liquidation process regulations, the proposals relating to that. We will be following certain rules here. One, discussion to be very specific, laser-like focus on the issue that is there in front on the table. Two, only one person speaks at a time, and so kindly use the raise hand symbol when you want to say anything, and you will be recognized. Everybody will be given opportunity to speak. We will ensure that. And thirdly, of course, because time is limited and we are covering two papers, so let us keep the discussion as succinct as possible. So having said that, I will now keep a PPT on the screen, but that is just to aid memory. We will be focusing only on the specific issues. Okay. I presume it's visible?
Yes, sir, it is visible.
Yeah, so we are going to the first one, that is enabling entities to become IPs. Okay. The heading is entities, it is not IPEs, because I don't know, maybe in future they would like even other entities which are not IPEs to become eligible. Okay, right. Now what I have tried to put up here is the final proposed regulation. Okay, not the prior discussion. The assumption here is that all of us, we have actually read the papers. We have understood what is being meant and what is being sought to be achieved. So we will focus on what is the proposed draft regulation largely, and if there is any issue with that, or we accept it as it is. Okay. So the first proposal, the substantive proposal is on Regulation 4 sub-regulation 2. Now this is being added, right, in the Insolvency Professionals Regulation. And what is being added is that no insolvency professional entity recognized by the board under Regulation 13 shall be eligible to be registered as an insolvency professional if, okay, in case of a company, subsidiary, joint venture, associate of another company, it is itself undergoing an insolvency resolution or is an undischarged bankrupt, one of the standard clauses. And C, all the partners or directors, as the case may be, that means LLP or company, as the case may be, are eligible under clauses A, B, C, D, E, F, and G of the original subregulation, which is now numbered as subregulation 1. Now, what does that say? Okay, let us look at that. Now, 4.1, it's got up to A to G, so many clauses, but the one which is important for us, because the rest are common, does not, this is talking of no individual shall be eligible to be registered as an IP. Now, who is the individual here? Either a director or a partner of the IPE, which wants to be registered as a IP. Now, none of them will be eligible unless they have the qualification and experience specified in Regulation 5 or Regulation 9. Regulation 9 doesn't exist anymore. So Regulation 5. Now, what does Regulation 5 say? Among other things, it talks of having passed the limited insolvency exam and having completed the PREC. So the substance of this entire proposal is that all the directors or the partners, as the case may be, need to be eligible to be IPs. It doesn't say that they have to be registered to be IPs, but to be eligible. That means they should have been enrolled individually, and they should have passed the exam. Obviously, after that you get enrolled, and also completed the PREC. There is no mention specifically whether each one of them needs to be registered. Okay, so this is the Regulation 4.2 as proposed. Floor open for comments. If this looks okay, nobody has an issue, then we will straight away move to the next one. Anyone has a comment?
So when we say has completed a pre-registration education training course, so that means all the partners there must have completed the PREC.
All the partners or the directors, as the case may be. Partners if it is a LLP, directors if it is a company.
And similar with the case with limited insolvency examination.
Yes, you can't do a PREC unless you're enrolled. You can't enroll unless you're done a LIE. So LIE, enrollment, PREC. But no mention is there of whether such a person has to be registered also. It just means that you have to follow this. Now, it's possible that this is not the intent, that this may be an exception may be given. We don't know, but as of now, this is how it stands. If you are okay with this, we'll move to the next one. Anybody has any comment on this?
I even posted in the chat, sir.
Chat is difficult to read.
Doesn't matter. Okay, I'll just convey
you can just, yes, spell it out.
My question is, what about the IPs like me who had already, we were enrolled without pre-registration course.
You're still an IP, you're a registered IP.
That's what I'm saying.
Because, see, at that point of time, this is all the changes are with prospective effect.
Perfect. Fine.
Okay.
Thanks for clarity. Okay.
Unless, of course, it can be with retrospective, specific. It has to be explicit. In this case, it won't be. All those IPs who had got registered in the regime before PREC came into being, obviously continue to be IPs. So, okay, fine. Now we go to the next one. The next proposal is in relation to subregulation 7. Okay. Now this is in case of an IPE. Now there is an addition. In case an IPE is the IP, it shall. Okay. Now and just reading the major ones. Allow only the partner or director who is an IP. Now slightly different from what we have seen under 4. 4 talks of all partners or directors being eligible to become IPs, not necessarily registered. Okay, because that part is not there. Here is very specific. that the IPE may bid and take an assignment in its own name as the IPE, but it will have to designate a signing partner, the way audit firms do in accounting audit firms. Similar, something very similar. I think the structure has been borrowed from there. So only the partner or director who is an IP himself shall sign and act on behalf of it. That means the one who will be executing and signing both. Then there are disclosures. Okay, how much capital employed, not very important, routine, I would say. Then talking of liability. Now, liability jointly and severally, along with the partner who signs. Okay, then that means the entire IPE is liable, not the other partners. What is being proposed here is the IP, who is the one who is going to execute the assignment, the signing director or partner is primarily liable, but also along with him or her, it is the IPE, the entity, which will also be jointly and severally liable. Okay. 3 and 4, one talks of partner, the another talks of director. There is a minor typographical, I think, error there, the placement of the article. But other than that, it is basically the same thing as the first one. So, any comment? View, opinion on this provision? We are okay with it? Joint and several liability?
But when we say joint liability, so can we envisage some situations wherein the partners who did not took up that particular assignment, and they would say that why the entire IPE we made liable, and for the litigation may be there.
But that question doesn't arise because when you are getting registered as an IP, no, if you are an IP and you are wanting to get registered as an IP, then this is a precondition. Without that, you don't get registered. You are signing up for the condition. You can't later on turn back and say, no, that is pure estoppel. So you can't first agree and then say, no, no, it's not politics. Politics mein hota hai, yani. Okay. So that situation cannot happen because no partner can say, why is the firm liable? But of course, the partner can say, I individually am not liable because I am not signed up for that. That partner A has been charged with something, a commission or omission of whatever his duties. Then can partner B become liable for the same? The answer, as per what we can read, plain reading of the regulation, no. But the firm, yes, the firm or the company. Yes, ma'am. Go ahead.
Good evening, sir. Good evening, everyone. In the case of IPE or entities being made as insolvency professionals, if there's a disciplinary action, the artificial person does not undergo any disciplinary action. It's mainly the individual, isn't it?
Yes, you raised that. I think in a way, okay, disciplinary action, that part of it, the proposals have not come. One would assume that they will fit into that. The normal course, what happens is that the juristic person is fined because you can't send them to jail or something, but registration can be cancelled. So the disciplinary action could be against the firm. Because here now the firm is registered as the IP. So all the disciplinary regulations relating to an IP will apply equally to the firm. So it could be that the individual and the firm could both lose their registration or be penalized, fined, or a combination of both.
So if there are individuals who are part of the IPE as directors, but who do not sign the documents in an assignment, they will also be penalized if there's a disciplinary action, isn't it?
No, the individuals are not, because the liability of the firm as a whole, but not the directors or partners individually. So it's like section 138 in a way. I mean, I'm just stretching the example, but the firm can be fined and the signatory can also be fined, but not the others who are not involved, So here the signatory and the firm, but none of the other directors or partners. Unless, of course, in a particular case which goes beyond where they are also involved, that's a specific allegation would be there, but not in general.
The way I look at it, I'm sorry, I may be very naive, but I want to express my concern. See, with this, what can happen? Most of the bigger assignments will go to an IPE. And when there's any default, in their performance, then all other directors will move out and start another IPE, or independently they will practice, like what happens in the CA forms. So this is what I think is going to repeat in this case. This is my fear. I'm sorry to say this, but this is a fear. Thank you.
See, gaming of a system is, I think, at least 10,000 years old and will forever be there. As long as human beings are there with self-interest overriding anything else, these things will happen.
Yeah, but
we can't stop doing something just because somebody will game the system. That will happen. And the system reacts basically, right? When something like that happens, the regulator, the government, or whatever will react and try to plug those loopholes in some manner or the other. We don't know. But see, let us look at it from as an IP perspective. See, the entire discussion today is not from a top level ethical moral perspective of the nation building or what. We're looking at as IPs. Do we have an issue with this? As IPs, that's it, nothing more. Somebody else, 2 houses down the lane has doing something illegal, immoral, or whatever. Not exactly concerned with us as IPs. As citizens of the country, yes, one can do whatever you want. But as IPs, I don't think that we should be concerned with what people do to game the system. It has nothing to do with us.
This is, I'm sorry to intervene. I think this is 100% verbatim taken out of the valuation rules. So, and the other issue, which probably is that because the quality processes within the firm needs to be immaculate in place. That is why both should be So that's why the firm should also be liable in case of any kind of negligence.
It is liable. In fact, that is what I said, that the firm has been made jointly and severally liable. Okay, but not the other directors and partners who may not be party to this particular assignment. Why should they become? So fair enough. I think they have done a balancing act between the two. So that has been done. Shamalji, boliye.
Mr. Ravi, my question is, that means when this 7I is there, it allows only the partner or director who is insolvency professional to sign. That means it says that no IP firm can sign on that. So it cannot be signed in the firm name. I mean, assignment cannot be taken.
It is like the audit thing. You can appoint a firm as the auditor of the company, and then they designate a signing partner. So here, what is happening is that the IPE is effectively getting the engagement letter or appointment letter as an IP, and the IPE in a way decides who shall be executing the assignment. Okay, of course, in practice, you might have to give it right up front, and the applicant creditor might want to know which particular person is going to handle this assignment. But those are not part of the statutory regime. Okay, they could be contractual. They are not part of the statutory regime. So the IPE is the one which gets the assignment in its name as an IP. And then there is a signing partner or a signing director.
And despite having a partner or an individual, accountability squarely lies on the IP.
So the primary responsibility will be on the executing IP, always. The one who signs is always primarily responsible, but there is a joint and several on the firm also. That is add-on. Okay, so both. That's why I try to give the example of section 138 of NI Act, where the company as well as the signatory on the check both are liable. Okay.
Sir, little more I want to say about this. In fact, Mr. Sahu sir is also here in the participants board panel. In fact, the initial funda, when IBC was enacted, was that why an individual is appointed as an insolvency professional is that because a CEO, a company cannot be appointed or a firm cannot be appointed as a CEO. Only an individual can be a CEO, and he has got a lot of responsibilities personally, and he is also given professionals to support him, to assist him in this. That is how only an individual will be appointed. And the top 12 cases of the country were executed by these so-called individual CEOs. And today, what is the need for this IPEs to become insolvency? And where is it then today? Are we saying that a CEO and a company or a firm can be appointed as a CEO? And the initial fundamental thing itself has gone for a toss. I'm just surprised actually with this IPE becoming an insolvency professional.
Yeah, you are, of course, not on the regulations proposed per se, but on the basic rationale itself of this proposal. That yes. Should even IPEs be, is it legal to make an IPE as an IP? Okay, a different subject altogether. I think many of us will have our own opinions on that. And yes, each one of us definitely is free. See, today's discussion under the aegis of this IPA or any other for that matter are to focus on the actual drafting of what is going to come. But it is also a request to all individually, those who are present, please go ahead, go on to the IBBI portal and please register your views there individually also. Please do that, okay? Because everything cannot possibly be captured in the group situation. So yes, I do agree with what you are saying. The legality of it is something which can be questioned, like any other. There is a rationale given in that. They have, I mean, if you read it, the definition of the word person, how is it defined in the act, then legal opinion from the governmental officer, all that has been given. Of course, these are just arguments. Anybody can have a different view tomorrow, and that's fine. Fair enough. Okay. Yeah. So this is the liability of jointly and severally part. Okay. That's how it will operate. Now the next regulation which has been proposed. Okay. This is 12.1a, which is being added. It's sole, I mean, this is being modified. This is talking of what is an IP, what is its objective, right? The first part was already there. Its sole objective is to provide support services to IPs. Yes. Now what is being added, or to get registered as an insolvency professional under Regulation 7, subject to meeting eligibility under Regulation 4. I have highlighted the word or because there is a bit of because of the drafting. Does it mean you can do only one of the two or both? Okay. In normally when both are allowed, then at the end of the clause, it's usually added or both. Okay, it's missing here. Is it deliberate? Is it oversight? We don't know. But that is that. Then the one about control. Okay, the net worth criteria, etc. Here, this is being said majority of its equity shares. There was some confusion, or rather some thought for some time, that net worth can be by way of equity plus preference, and which one is the majority. The Tata case, I think, was fresh in everybody's mind as to how do you decide control. So that is being clarified. Majority of its equity shares and voting rights to be held by IPs. Now this is very clear. Insolvency professionals, not just being eligible to become IPs, but being actual registered IPs. Okay, who are its directors in case it is a company. In the case of LLP, such a provision is not required because automatically those who own are the partners. Okay. Yeah. Any question, comment, response on this? Clear? I put presume. Okay, that's nice. We're doing quite speedily today. Good. So now this finishes the IPE as IPs as far as the draft regulations proposed. I have not covered all the regulations because some of them are pure procedural or consequential to the main proposal. But if anybody has a comment on that, can definitely raise that. Okay. So now we will proceed to the next one, which is slightly longer because there are 15 proposals in that. A total of that. And here we will be covering the proposals per se. Yes, Avinish ji.
Sir, just 12(1)(a), what does it signify or to get registered as an insolvency professional regulation 7? It says its sole objective is to provide support services to IPs.
Okay.
So meaning thereby, I'm sorry, meaning thereby that means the IP shall be registered as an IP. Do you mean to say that?
Yes, we are talking here only of IPEs. Okay. This entire thing is only making an IPE eligible to become an IP. Okay. No other entity.
Agreed, sir. So do you mean to say, I'm just sorry for repeating it, just for my understanding. Do they mean to say that that particular IPE entity shall be registered as an IP under regulation 7?
Yes, absolutely.
Okay.
Absolutely.
Fine.
Yes.
Thanks for clarifying.
Yes, they have to pay fees separately. The fees are going to be much higher. So yes, 2 lakhs. Okay. If you want to be, if you are an IPE which wants to become also an IP, then the registration, one-time registration fee, non-refundable, is 2 lakhs.
Good.
And plus, of course, annual, etc.
Sir, then who is going to write the examination, sir? Is the IP going to write the examination? For become an you qualify an examination. Then who is going to write the examination?
Okay, Mr. Shivaraman, I think we covered that, but I will repeat it for your benefit again. That is covered under the previous regulation, okay, where it says that in regulation 4 itself, where it says that all the partners or the directors have to be eligible to become IPs. That's number one. Second, it says the majority of them in case of a company shall be IPs holding majority shareholding. Okay, so this is covered. Third, that the signing partner or the signing director has to be an IP. So, see, firms don't give exams, no baba. Qualification is of the individual always. So the individual with this authorized signatory or the designated signatory. In this case, I would say not just authorized because it's not, it's for the entire assignment. So the designated partner or director will be the signing party and he has to be an IP. So both, that means the person executing it and the entity, both have to be IPs. So both will pay their annual fees, etc. Okay. Commercial wisdom is very important, sir, in all these proposals. Okay. Now we are going into streamlining of the liquidation process, and here we will be taking not the draft regulation per se, but the proposal, because it's easier to understand and we can easily understand the regulations after we go through the proposal per se. Okay. So there are 15 proposals, and we will go through all of them one by one. So the first one is the constitution of the Stakeholder Consultation Committee, SCC. Now, what is being proposed? That the COC, as constituted during CRP, that means at the end of CRP, shall function as the SCC. It's like an interim government, okay? Caretaker committee, till the actual SCC is constituted. Okay, so that means that there is no period between CRP closure and liquidation commencement, or till the claims during liquidation are adjudicated, received, adjudicated, etc. So there is a body to aid and advise the liquidator throughout this process. Okay, different functions. The interim committee, which is the COC. I call it the interim committee. The word is not used anywhere, but the SCC during that period shall be the COC as it was. And after the claims are received during liquidation, adjudicated, etc., within 60 days. Now it says that the new SEC shall be formed, which shall comprise of all those stakeholders having voting rights. Now only voting rights. Okay. This is changing what was there earlier. Earlier, people who did not have voting rights under the waterfall also were part of the SEC and actually had one person, one vote type of regime. Now this is being changed to be more or less aligned with the way the COC is formed. Okay, except that it is updated for the claims. And here the voting rights shall be based on, now slightly different, it is not on claims anymore. It is based on the amount that would be payable to each stakeholder if section 53 waterfall is followed using liquidation value available as the reference. Okay, when we come to liquidation value, we will see that it can also change with time. Okay, so this is the proposal number 1. Very significant change that has been proposed.
Raviji, your voice is breaking.
Oh, okay.
We can't hear you clearly.
I don't know what to do. Okay, let me see. Okay, let me then maybe it had I'll change my. Vikram.
Yes, now it's much better.
Okay, right. Okay, there's some, I think power has gone.
Now it's better.
Okay, so this is the proposal which is there, that there shall be a interim SEC which will be in office for a period of maximum 60 days from liquidation commencement date, which will be the COC as it was prior to the liquidation. And then the new SEC shall be formed, which shall be based on the amounts payable as per the section 53 waterfall based on the liquidation value. Yes, Bhuvaneshwari.
Yeah, basically what I see is that from day one till the stakeholder committee is actually formed, you cannot live without COC. So the previous COC is brought into the liquidation. That's what I understand, but I don't know what we are going to achieve out of that. Maybe some of the professional approvals and all that maybe will be taken care through this. But otherwise, I don't know what is the purpose behind it. And
there is. When we come to the other proposals, then we will see.
Yeah. In the first para, it says the stakeholders who are part of the COC without voting rights will be part of SEC without voting rights. Means, is it like who are part of COC without voting rights means they are related party? No, he is not part of COC. So who is part of his COC without voting rights?
Yeah, okay. I'll tell you who are the part of COC without voting rights. All the directors or partners, as the case may be, who are invitees, they are without voting rights. They are part of the COC. Operational creditors who are above that threshold of 10%, who are invitees. Okay. So these are the two categories who are definitely part of the COC, but do not have voting rights. Related parties are never part of the COC in any manner other than directors.
Even directors are not part of COC.
Yeah, they are, madam, please read. They don't have voting right, but they are part of COC. See here, the part of the words part of COC has to be understood in the expanded sense of participants of the COC. Okay, so all those who were participating earlier by right, okay, not by invitation only. Sometimes you invite certain people to the COC, but those are specific. So those who participate by right in the COC earlier will continue to be part of the COC and will not have a vote even here. Okay, they are just observers. And when we come to the other proposal, what this first COC is going to do, it has a job to do. Okay, then you will realize what is meant by here. Okay, Partha Kamal Sen. Mr. Sen. Hello. Okay, he's not there. Mr. Ramesh.
Yeah, in the last line, in case any valuation is undertaken subsequently, voting rights of the stakeholders may be revised. But voting rights per share percentage will be same because only liquidation value is changing, but not the internal vote, share of each member.
No, it may. Go back to what is waterfall. If the LV is 100, the waterfall, let us say, stops at 53(1)(c). If the LV becomes 200 tomorrow, I am giving hypothetical. It may go to D and E. New members might come in. Okay.
Okay.
To that extent.
Okay.
And another thing about charge, first, see, the amount payable to each one might differ. So we will not make an assumption. It can change. It is okay. Mr. Anil Vaidya.
So this related parties will be having voting rights in SCC.
Related parties. Sorry, kya bole? Yeah. Yes. During the liquidation process.
Yeah.
Yes, because that, at least from what I could read of the proposal, that exclusion is not there, which was there during the resolution phase. So it is all about recovery, right? Recovery, and if you look at the duties or the powers of the SCC, they are not about approving proposals per se so much. I mean, proposals of how to resolve that. They are only about cost control, largely. Okay, what cost? So everybody has a stake. Even related party has a stake. The related party doesn't make that person, untouchable. Okay, it's just that for a particular reason, for a particular time, they have been excluded from the decision-making process, but not that their rights have got extinguished. No, they still remain. So in this case, from what I can read, I may be wrong in this particular, but I didn't really find anything which excludes related party from the SCC as such. But I may be wrong.
Sir, can I ask you? Hello?
Yes, Mr. Sen, you were missing.
Sorry. No, actually, I was moved. Sorry. Sir, my point is that as per the current position, after submission of resolution plan, the COC doesn't exist, isn't it? So now,
which provision of the code or regulation says that the COC ceases to exist after submission of resolution? So explicit, okay. This is what many of us commonly understand, but there are many people who have a different view. And COC meetings have been held after submission of resolution plan. Mostly,
there are many case laws, but so the COC exists to. I mean,
ऐसा specific कुछ नहीं है. That could be very, very situation specific. Case laws are dangerous when quoted out of context. So this.
But my point is that, sir, now what's happening? CAC will exit after submission of resolution plan also.
Yeah, see, in a way, that part, this misunderstanding that COC ceases to exist in totality after the resolution plan gets approved is being removed by this. That's why I said now there is no gap. The COC continues to hold not only submission of resolution plan, but right till the new SCC gets formed, the COC will remain in existence. But now it will be changed. The name will be SCC. Its powers will become advisory, not mandatory. Okay. In as a COC, it was always mandatory. I mean, what do you call the decision was final. Here it is an advice.
Okay.
Subject to conditions, of course.
And my second point is that if you say that need to call the first meeting within 7 days from the liquidation commencement date, so what will be the meeting will be called? COC meeting or SCC meeting?
No, it is the SCC now, except that it is changing form. Now avatar change ho gaya, label. Think about it that way.
Okay. So it will be a SCC meeting, but with the members of COC.
Yes, the same members. Exactly whatever was there earlier for a temporary period. It is like an interim cabinet, you can say.
Okay.
When one government falls and another is supposed still to take over.
Caretaker.
Caretaker, yes. Yes. Okay.
Thank you, sir. Thank you.
Any other question, comment? Shall we move to the next one? Okay, right.
Sir, if anybody would like to have any comment on 60 days timeline.
No, if nothing has come, this is not the new, it's the old one only.
Sir,
So,
one question.
Yes.
Sir, the SEC committee, that meant only the secured creditor will be having the voting power. Am I right?
No. That's an assumption. You are making that the LV is so small that only secured creditors get. That's an assumption. It may be reality, most cases, but that is not the law.
But
the liquidation value of the assets covers unsecured financial. It can cover unsecured financial. Who said it cannot?
Liquidation value mean how it can be? There is no liquidation value for the unsecured creditor.
Oh, what? Sorry. I think there is a fundamental error you are making in the concept of what is LV. We will need to let us discuss this offline because this is very basic. Okay. You can call me anytime. I will explain to you what is meant by liquidation value. Okay.
Sir,
but that's not what is your concept is not correct. That much I can.
In case any valuation is undertaken subsequently, voting rights of the stakeholders may be revised accordingly.
Yeah.
If any valuation done mean only secured creditor will be having value, all the stakeholder valuation will be zero.
Mr. Arumugam, you are making a very, very fundamental mistake. You are making an assumption. Let me just give you an example, very simple, just 30 seconds, and then we will not discuss this further. Okay, let us say that the secured creditor claim is 10 and the liquidation value of the property is 100. It can happen?
Yes.
Then liquidation value is higher than secured creditor, no?
Sir, in claim, I do accept. If you are based on your claim,
reality, please don't bring examples to law.
Valuation.
Law covers all cases, okay? Not just the current reality. And if you have to talk of current reality, there are a couple of cases, okay? Well, look at Binani. Binani, everybody got paid. Okay. So we are going to proposal 2, which is the role of the SEC. Now, what is the role of the SEC? Whatever was bit of clarification which was missing earlier, that is now clarified. So they will be party to deciding remuneration of professionals. Sale under Regulation 32. This is going concern or sale of the business of the company. Manner of sale, which means how it shall be carried out. Pre-bid qualifications, that is the equivalent of the EOI and the tender conditions. Reserve price, that is setting the reserve price. Amount of EMD, marketing strategy, need for fresh valuation. Okay. If the valuation as available, which is what was done during the CIRP. If there is a need, either because of lapse of time or any change in circumstances, then the need for fresh valuation also will be an agenda item before the COC.
Sir, I have a query out here.
Just let me complete this para, then it will be open. Just wait, hold on. Okay. Now, SEC shall advise the liquidator. The word is advise. The SEC is not deciding. It is giving advice through a voting mechanism. Vote same 66%. Okay. Present and voting. Now the big difference. This is not there in COC. COC was absent is equal to negative vote. Here it is not. So here it is the present and voting regime. Whoever is there in the meeting and votes either way. Absent. Those present and voting in favor has to be 66. Okay. Which is the general rule in most voting cases, except COC. Now, the liquidator, if he takes a decision which is contrary to what the advice of the COC is, now the COC, the SEC decision advice is not binding, but now the big but. If the liquidator decides otherwise, then he will have to write the reasons for the same, write it down, and forward it by way of a form. There is a proposal to have a separate form for this to be prescribed by the board to both the board and the adjudicating authority within 5 days of the decision. Yes, now ask your question.
what happens previously before this proposed amendment, that normally that SCC recommends the fees of the liquidator by way of resolution, and that is getting approved by Honorable NCLT.
We have not yet come to fees.
Come again, sir?
We have not yet come to the proposal of fees. It's a separate proposal by itself. We will come to that.
No, you mentioned there, na, like, SCC is going to decide.
Oh, that is the job of the SCC. I was just mentioning, just clarify. These are the things they are required to do, which means the liquidator needs to go to the SCC for advice on these matters. Okay. Right. So, any other query or comment on this? This is largely
Raviji, it looks like actually the creditors in control will continue beyond CIRP right up to the liquidation.
There is a change. It's no longer binding to accept what they say. But like somebody said, no, if the promoter makes a suggestion in a board meeting and says it is only a suggestion, but let's not forget who is making it. So, ye vaisa hai. Yeah, see, there is nothing wrong with it. It is not a new proposal. It is been existing under winding up regime for decades all over the world. So nothing new about it. Okay. In fact,
but official liquidator as per the High Court rules used to have a lot of independent powers and independent things actually. So here liquidator will be continuously guided and directed by the SCC, which I see actually into this particular proposal what the amendment has come now.
Yeah, we know which. Do you have a specific problem with a particular item?
No,
part of that?
I'm not saying that. I'm saying generally now, as I read it, the whole thing, not only this particular section and even earlier other sections also on that. So changes basically aimed it that along with the liquidator, the COC in different names will continue to be there actually on this.
See,
and
the stakeholder consultation committee is ultimately the beneficiaries of the liquidation, right? Now,
yes, beneficiaries.
That's all that is. And the beneficiaries do not have a say in the process of recovery was always illogical, frankly speaking. Okay. So, some third party comes and decides what is good for me about my property. If it is put in those words, you will realize that it was always, this was a lacuna. This is actually a great proposition that fills up that gap of what is the real role of the liquidator. The role of the liquidator is that of the executor of what is to be done, and not to, being a total adjudicator. Yes, adjudicator role is a very limited one, limited to verification of the claim process, not beyond that. Liquidators have been thinking, we have found many people thinking that they are lords and masters of the process once they get appointed. Not true. They have no stake and they cannot exclude people with a stake. It's very silly. It goes against the basic logic. So this proposal actually fills that gap. Is okay. As a moderator, normally I don't give opinions, but in this particular case, they came up, I'm saying that yes, this is what it is.
No, that what makes you to think that why the liquidator was left like that earlier actually? I mean, what was the thought?
I think it was just overlooked, nothing.
It was never there is a deficiency rectified. Deficiency
never
rectified.
Yeah, it's just a gap that is being rectified.
So here I would like to add something. When this concept paper, myself Vishal Agrawal, when concept paper for insolvency was propagated, it was a shareholder in control regime to be given to the creditors in control. And thereafter, if creditors fail, in first case, if shareholder fails, control is given to creditors. Now, if creditors fails to resolve the company under CIRP, then control is given to the liquidator. Now, liquidator is being, no doubt, suggested and will be guided by, will be supported by the SEC, but should not be capped, should not be controlled by SCC, in my view.
No, this is, if you see that the word used is not the decision of the SCC, but advice. And the liquidator specifically continues to have the power to differ from the advice given, but then has to give reasons for that. Okay. It is not even stopped. It doesn't even have to seek permission. Remember this, I as a liquidator, I don't agree with whatever a particular issue, the advice given by SCC by the requisite majority. I want to do something different, then I can do that. But then I have to write down reasons cogently and be able to defend it tomorrow when challenged, that it is not for personal gain, it is not arbitrary, it is not without application of mind. All those things have to be done, which is true for any public official. Nothing new. So what is being put in place is the public authority standards of conduct, which are set down by time immemorial all over the world, that people have to be rational and give reasons why they do something or don't do something. It's just being produced in paper, nothing more, nothing to worry about, I would say. Okay, third one, relinquishment of security interest, a topic of interest, I am sure, because I think a majority of liquidators have had problems with this as to the delay it takes in relinquishing. Now, what it says, okay, this is interesting. First meeting of the SCC. Now, this is the meeting called within 7 days from liquidation commencement date, comprising of the pre-COC as it existed earlier. Every secured creditor in that meeting has to intimate, whether they are realizing their security interest or relinquishing. No more time gap. See, all the proposals in this discussion paper are primarily aimed at reducing the timeline of liquidation, from what it is exactly happening now. So first meeting of SCC, each secured creditor has to indicate whether they will relinquish the interest or not. Okay. If they do not indicate in the first meeting, then the deemed fiction comes in. It will be deemed that they have actually relinquished their interest, and the liquidation process can go forward after that. Okay.
Sir, do you
one second. Now, the next part is that secured creditor who has not relinquished interest cannot be part of SCC. This was existing earlier too, indirectly, that the SCC is only those who have relinquished interest. So it is just a clarification. Yes. Now, I think Mr. Anil Vaidya raised his hand. Yeah.
In case of pari passu charge, 2 or 3 secured creditors, they have difference of opinion. One wants to relinquish, one doesn't want to relinquish. So what will be the solution?
You have asked a question which is beyond the scope of this discussion, but yes, I think it has existed even under winding up and all that. What happens pari passu? There are certain practices that have evolved over time. And one of the things that generally people fall back on, because that clarification is given in SARFACI, not in other acts, but in SARFACI, that where there is joint charge, then the 60%, if I remember rightly, by value, have to approve for that, how to deal with that asset. Then it can be enforced. So similar. And since most decisions relating to realization of security interest would actually be conducted under SARFACI by the creditors. I'm not saying all, but most. So the SARFACI rules will apply anyway. So that is one way out. But as I said, that is not really the topic of today, because it's...
The situation may arise for the...
Yeah, it does arise. It's not new. It arises. Mostly they sort it out themselves. The general advice to liquidator would be, don't interfere in intercreditor fights. Let them fight it out. They will find a solution most of the time. Okay. Yes, Mr. Arugumukam.
Sorry, the security, the asset was relinquished and it's becoming a part of the liquidation asset. It is unable to sell the asset. If whether it is any provision to take back the asset by the old secured creditor. so that the winding up can be done.
Asset, the liquidator unable to sell it, and you are saying, ab kya kare? Yes, there are provisions. NRRA is there, not readily realizable asset. It would fall into that category, and follow those regulations as are stated under that. Okay.
It can be taken back by the old secured creditor.
NRRA does not say the old secured creditor. It says anybody else who is willing to give the better price. It could be somebody else of the creditors. It could be, instead of A, it could be B. See, you are talking very, very specific, extremely rare instances. Difficult to give you a solution in a public forum, which is for a general topic.
Right.
Okay.
Thank you.
Yeah. Okay. New one coming first time, replacement of liquidator. Proposal that the SCC, by a majority vote, again 66% present and voting, propose the replacement of the liquidator. Okay, it doesn't say appoint, it says propose, because liquidator appointment is by the AA and can only be changed by the. So this is the proposal that this is to empower the SCC and step in where required. Again, some questions might be raised. Okay, we will wait for questions to come from the participants. Mr. Sandeep Goel, Boliye.
Yeah, good afternoon, sir. So my question is that how the voting to be done during SCC meeting and the voting percentage will be counted. Like 66% is here in earlier.
Okay. Again, I think you probably joined late, so you must have missed that part. We covered it. Yeah. The voting percentage will be based on the Section 53 waterfall calculation.
Okay.
Based on the latest available liquidation. Okay.
Latest available
liquidation value, LV.
Okay. Based upon that, whatever the share the person will get, the voting will be decided upon that.
Yes.
But regulation is silent with regard to the same.
No, these are proposals, sir.
Okay.
Here, aayenge. This is future. We are not talking about what already happened. We are talking of proposals.
No, these are the proposal, but the voting is already there during SCC.
Which voting is already there?
In certain cases, whatever we have to decide, this is decides through the voting.
No, are you talking of the situation the day the new regulations come in? They are always prospective, Baba, never retrospective.
Okay.
Mostly, except in very rare cases where explicitly they are made retrospective, like filing of forms, for example. That is always includes the past assignment. Yes, Mr. Vaidya.
Sir, in this, COC doesn't have the power to recommend the appointment of liquidator. Under Section 34(1), resolution professional continues to be the liquidator if he gives his consent. So here, the authority is now given to SCC to replace the liquidator. So whether it can be done through regulations or it has to be done through amendment to the.
Just to clarify, the COC never explicitly had the power to recommend a person other than the existing RP as the liquidator. Very few cases, there are, where the RP has consented, but the COC has decided to have another liquidator. Now, in the case of liquidator appointment, it is like seeing a recommendation or a proposal made before a judicial authority is the equivalent of a petition. You cannot tell somebody you can't make this petition. It is for the authority to decide whether they want to accept it or not. It is just taken under advisement. So when the COC earlier and the SCC now makes a proposal that change this person, we don't want him, we want somebody else. That is just a recommendation, which is not at all binding on the A. The A will look into it and decide. The SCC is just being given the enabling power to make a recommendation. Now, was this power not available earlier? As a SCC, it was not, because SCC is a created body. But any individual creditor could always go, even now, and make a complaint and say existing liquidator is needs to be changed for reasons A, B, and C, and AA will hear it. Okay, so nothing, it's not something very new. Haji, Mr. Ramesh.
See, now liquidator fees is based on success. So when you are removing a liquidator after his service, maybe for 1 year, 6 months, I don't know whether subsequent proposal clauses are there. How will the fees of the liquidator, well, for compensating him, because it's based on success, and till he's removed, he might not have drawn any fees at all. So is there any provision for that?
No, there is no provision in the proposals. But see, we are talking who are liquidators or IPs. People with at least 20 to 25 years of experience, matured people who ought to know what they ought to do and not do. Nothing, once there is a regulation like this in place tomorrow, nothing prevents them from including that eventuality in their fee structure. That if you change me, I mean, CEOs do it all the time, right? The CEO of Twitter is likely to get $300 million if he's removed. So please make that provision, put it in the resolution, get it passed in time, do your job basically. Okay, don't keep coming crying IBBI all the time. Mr. Vishal Agarwal.
Sir, again compromise the independence of liquidator as adjudicating authority is not authorized and not have no jurisdiction to exercise exercise judicial review of commercial wisdom.
Where is commercial wisdom coming here in a replacement of a person?
Sir, for an example, if a liquidator work for 10 months and at the end of the 10th month, now SCC go to the adjudicating authority that we want to replace the liquidator for any whatever is the reason. Now it is on the verge of the liquidation of all the assets at that time. Now they want to save their remuneration to be paid to the liquidator, because nothing is said in regulation, nothing is said in the code how the liquidator, outgoing liquidator is going to be paid.
No, you are making certain assumptions. Let me cut you short a bit here. First of all, it's because it's going a bit off track. One, there is no saving of remuneration. Remuneration as agreed, either a regulation 4 or any other proposal as agreed beforehand, has to be paid. Two, incoming liquidator is not going to do work free. Okay, if he does it, fine, charity. Anybody can. Pro bono is always allowed in India. Three, where is the question of independence coming here? I mean, we are making an assumption that the SCC or the COC for that matter is composed of people whose only job throughout the day is how to, harass the RP or the liquidator. A very funny assumption to make. Most people are reasonable. They don't do that. This is not the only job they have.
Unfortunately, this is a hardcore reality of the.
It is not, sir. It could be the hardcore reality of people who either are unlucky or are making mistakes which they are not themselves realizing that they are doing so. Okay, it could be both. So to make a sweeping statement that this is how it is, and still the same people go and take the jobs again. So if it is so bad, why are we still here? So let me say, if you think that you are capable enough as an IP to be appointed as the CMD, okay, CEO come chairman, then for heaven's sake, start acting like one, not like children. Okay, so anyway, that we covered that. It is just a recommendatory power, not a change by itself. It will be looked into by the AA on merits and decided. And AA may not change because such changes they don't like. See, as far as the RP is concerned, it was there in the code itself. It was a substantive power given. Here, this is a power under regulation, subsidiary legislation. So it will be looked at in that from that perspective also. Okay, now fees. The SCC will fix or review. Why? Both the words are used. If not decided earlier, then it will fix. If decided earlier, it has the authority to review. Now, why should that authority be there? Especially when, if it was fixed by the COC earlier, and the COC is the SCC for the first meeting, it is the same set of people. Why should the power of review be there? The board feels that, because of the length of time that it is taking. I mean, this is a hard reality. They're actually recognizing reality and making a provision for that, responding to that. That it takes months, many months, for the proposal of liquidation to be filed and the actual liquidation commencing. And it's possible that circumstances might have changed during this period. So the SCC should be enabled to review it if it wants to. Well, one can say once fixed, why should it change? But then it is up to the liquidator not to accept the assignment. If the counter offer or the revised offer is not to the liking of the person, this is not mandatory duty to take up an assignment. All these are voluntary. But that is the background. Yeah, Mr. Markov. Yeah.
Yes, sir. Sir, actually, as you rightly said, and with this new proposal, keeping in line with that, whatever the process is taking time in that during this process. Suppose during the COC meeting, remuneration has been fixed. I'm not talking about that proposed amendment, but in some of the cases, what is happening nowadays is that because the time is the essence and time has is taking long. So, like, suppose a COC has decided the liquidator's fee, and now can the SCC has the power to review that?
That is exactly what this enabler is. That even if the COC has decided, and now this SCC in the first meeting is the same COC. Remember this, because new claims have not yet come. This is a meeting being held within 7 days of liquidation commencement date. The first SCC. So it is the same set of people. Same ABCD decided a particular fee for the liquidator. The same ABCD are being given the power to review it when liquidation has commenced. Now, why? The paper. If you have read the paper, you will find the reason given is that the significant amount of time that has gone between the decision to liquidate and the actual liquidation order. So it has been felt that the SCC should be given the enabling power to review it. Okay. And the circumstances have changed. What would normally happen? Okay. You can, yes, they can reduce it. Yeah. On paper, yes. In theoretically, yes. How many times will that happen? It's unlikely to happen very frequently, but there will certainly be cases. Then what do? You go to the authority. See, either you can refuse to accept or be good enough to negotiate. Maybe sometimes you can be good enough to negotiate upward also. Who says that it is only downward? If the liquidator finds that, after some time that, say, 3 or 4 more legal cases have come up now, maybe enforcement action by some of the agencies, and the workload suddenly increases, you can go back and say, okay, I agreed for a lesser fee earlier, I can't work on that, increase it. So it gives provision for both. Don't always look at it from one side, okay, only reduction. It can also be increase. Okay.
So, sir, you mean to say that after this, review, that whatever the fees has been agreed, it is to be intimated to AA?
The minutes of the COC meeting now have to be filed with both the AA and the IBBI. Filed, okay? No applications, right? It is just a file. Like along with the report, okay? Quarterly. Yes, Vikram.
So, Raviji, one small query. So we have a table of fee for the liquidator. At times, what we have seen that COC insists on a discount to the table. So I just wanted to have your view. Is it permissible to seek a discount on the table?
Okay. If you read the regulation carefully, the table is a residuary option, not the first option. Okay. Right. The first option is that the COC shall fix the fees of the liquidator. In case they do not, which means either way, then regulation 4 kicks in. Now COC is fixing your fees. Taking regulation 4 as a basis is also option 1, not option 2. Okay.
Right.
Sir, can there be two set of, proportion, like, one is fixed and the other one is as per the table? Is it possible?
No limitation imposed by the code on regulation on how the fee shall be. It can be fixed, it can be variable, it can be mix of both.
Okay, sir.
Total freedom has been given. So exercise it or utilize it or take advantage of it to the extent possible. Okay. Yes, Mr. Ramesh.
I think since the power of review is proposed to the SEC, the last word in its first meeting should not be there. They should be given the power to review during the liquidation process, because 1 week from so-called LCD will also be a small gap sometimes. And
why? Okay, why it is given 1 week? There is some thought process behind that. Okay, it is the same set of people who were with the process for at least 9 months, if not more. Okay, they know everything of what is happening, and they have waited from the time they approved a liquidation till the time the liquidation order came. Okay, which may be 3 months, 4 months, 5 months, whatever, or it could be 30 days. We don't know. So it is an enabler to them. It is up to them. They want to propose it. Yes. See, it actually is a protection to the liquidator. If you don't do it in first meeting, indirectly you can't do it afterwards. It's saying so without saying so. Okay. So, jo karna hai first meeting karo, so that it doesn't happen that the liquidator has worked for 6-8 months and then they say, we want to reduce your fees. That is not allowed. That would be unfair. So before the liquidator starts work, because first 7 days, no work, right? Hardly anything. You want to review the fee, do it now. Afterward, you can't. So I think it is that part has been taken care of. That it will not be unfair or unjust. It won't be a sword hanging on the liquidator's head that the fee can be changed anytime. If the situation is not different in CIRP, there has been that one case where they did it, but I think that was specific case related issues. We cannot make it as a precedent, or it is not binding law to that extent. Okay.
However, right. I still have a small point that situations in liquidation, sometimes it may take 1 year, 2 years, or whatever. In such a situation, since SEC also will be same, mostly secured financial creditors, as you rightly said, CIRP, COC itself will normally continue in the SEC generally. So this limitation of first meeting may also be relooked. I don't know whether we can.
No, why you want it from the liquidator side, or you are thinking from the creditor side?
No, I'm talking from a unbiased legal position. That is
legal position. There is nothing illegal about this proposal.
No. What I am saying is, for example, because of COVID, 1 year is lost. So now second year is being done. So there are.
Okay, now I understand where you are coming from.
Yeah,
okay,
there are
I got it. I got your point. You are talking of a regulation 4 regime where the rate of fee keeps coming down with time, and you want exclusion. Okay, I think. Well,
no, I'm only saying the power can be left with the SEC in a practical manner. Need not be the first.
Well, pandemic is something I doubt if any law can take care.
No, not pandemic, sir. Even asset also, sir.
No, if you can't sell the asset, the assumption here is the liquidator is inefficient. That's it.
No. That is not correct.
No, that's okay. That you fight separately. I am saying
even SEC also will agree.
We are not going to get into Ramesh Garu. No, this is not an argument we should have whether liquidator is good or bad.
No argument. I'm only suggesting 1 second. The SEC itself will be convinced that there is a need for review. In such case, when you are giving the SEC the power in the first meeting, there's no harm in extending it to
extending the power. Okay, that is your suggestion. Yes.
Right.
Yeah. Okay. Fine. Okay, proposal 6, compromise or arrangement. Here we are talking of the references to section 230. It is not clear that whether it covers regulation 32 also, though the draft regulations do talk of that too. Okay. A slight background behind this. Now the 90-day period which was allowed for a compromise or arrangement under 230 initially in the regulation is proposed to be cut down to 30 days. Again, it is based on practical scenario as it exists, that at least a minimum of 60 days, in most cases, sometimes more, is the time elapsed between filing the application for liquidation and the liquidation order actually coming. What the board is proposing, very creatively, I would say, that don't waste this time. You want to do 230 at this time, please go ahead and do all the, explore that process during this period, so that when the liquidation order comes, you are ready with everything, and then you can actually complete it in 30 days. Okay, that is the thought process behind it. I'm not saying right or wrong, but that is the thought process. So,
any example, Ravi?
Okay.
Any example of successful 230?
1 second. Also, they have given example in the paper. I think I would presume people have read it, that there are hardly 4 or 5 cases where such a thing has happened.
Yeah, that's right.
Okay, in the vast majority of it, it is so minuscule that to carve out exceptions in the act for that, it is better to do this way. That is the thought process. That let us not give too much time, because while it has been given as an option, see, this option existed in the Companies Act for quite some time. 1956 Act had it, 2013 has it. Prior to that, even the 1913 Act had it. And largely it was judge-made law, where courts used to step in and say, explore this process. Can that company be revived again by some way? The reality is that, if you take 75 years of Indian independence, there may not even be 75 such cases. There may be 7 or 10 or 12, which actually happened to be resolved even under the Companies Act regime. And we are looking at under IBC, it's 4. And really speaking, if you look into the details of those 4, they're actually liquidation being called as Section 230. Okay, nothing was there, assets being sold, but putting the label of Section 230. So this proposal is basically reacting to reality. Okay, and taking away unnecessary time which was otherwise provided and being misused. Okay, being misused. That is the whole point, both in terms of extending the liquidation process and as well the cost involved. Any comment?
Liquidation period is now restricted to 1 year?
That still remains, because extension is with the, see, the code does not restrict the liquidation period, only the regulations do. Okay.
Yeah.
And they specifically say extension can be given by the adjudicator. Yes, Mr. Armado.
Sir, in CRP, approval of resolution plan requires 67%, 66%, whereas here in Section 230 of Companies Act, it requires 75%. Is it not little?
Yes,
different?
You are absolutely right in this, that Section 230 not only requires 75%, it requires 75% of every class of creditors, not just an SEC or a COC or one particular thing. But what is happening, the way these 3-4 cases have happened, because the Companies Act allows this, right, to dispense with meetings of creditors when the amount payable to them is known by law. So in all cases that I know of, they have gone and said Section 53 will be applied, proceeds will be distributed as per that, that being fair and statutorily allowed. So all the meetings have been dispensed with, and the 75% thing, in fact, there is no meeting held except that of the secured creditors.
Thank you, sir.
Okay, next proposal, 7th valuation. Okay, now this is the second valuation. This existing regulations talk of some very weird 7 days time, that within 7 days or so of liquidation commencement date, the liquidator has to take a call whether new valuation needs to be done or not. Definitely nothing can be done in first 7 days. So now it says at any time, okay, without saying so, where the liquidator of the opinion that fresh valuation is required, then based on a advice of the SEC, such valuation may be considered. But it says very specifically that for subsequent auctions. That means at the first auction, if new valuation is not decided at that time, go ahead with the old one as a basis for fixing reserve price, whatever. But at any time later, if you get a new valuation done, that can become the basis for subsequent auctions. So this is flexibility being built in to take into account change in circumstance and the time that has elapsed from the CRP closure to during the liquidation process. But it requires SEC advice, okay, with the same caveats that it can be overruled by the liquidator with reasons. Submission of progress reports, SEC minutes, purely procedural, nothing really to discuss. I'm sure you all agree to that. It is only clarifying what was already there in the code by way of regulation, nothing more. Okay, auction timelines. Now here, this proposal is actually based on a finding which I would say doesn't speak well of the IP community. Because basically it is said that liquidators are misusing the absence of specific provision to conduct auctions in such a manner that somebody is favored or somebody is not allowed to bid, etc., by giving very little time. So now the Schedule 1 does not specify any timeline as of now. They intend to have a timeline, which is a total of 35 days, 0 to the total 35, with specific 3 or 4 activities in between. Suggested timelines are there for in-between activities with the power to the liquidator in consultation with SEC to modify those as long as the total 35-day timeline is there. That means that the bid date from the opening of the auction should be 35 days. Okay, that is said to be mandatory. Okay. Any comment, view on this?
So, please clarify, sir. That means minimum 35 days should be the gap, is it?
No, it's not gap between two auctions. It is that bidding date shall be 35th day from the day you make the announcement.
Sale notice, paper ad or whatever it is.
Yeah.
Okay. Thank you.
And that's my understanding. Okay, unless somebody else has a different one, can clarify. Okay.
Subsequent one, Raviji.
Oh, aega abhi.
First.
Next one. But yes, a lot of work has gone into making this paper. And it has taken about a year and a half, 2 years of consultation. Right? This is not just one time. Over a period of time, various roundtables and other feedback coming in, the board's own observations on what is happening, analysis of liquidation processes. Now that is this is a culmination of all of that. Okay, timeline for successive auction. Now here the ground reality apparently is the opposite. Okay, the first one was the liquidator gives too less time for a serious bidder to come in. Now the second one is that they take too much time between two auctions. First auction failed, next auction 3 months, 4 months later, and that also cannot be allowed because that stretches the total time of liquidation. And the reason behind it, why should you wait for so long, etc. So the proposal is that in the event of failure of an auction, successive auction notice shall be issued within the next 15 days. Okay. Time period between two auctions for the same asset where a previous auction has failed, 15 days. Right?
Sir,
yeah.
A small point. You are allowing to make a move by the buyer to wait for a reduction. For example, if the first sale notice is for 100, he will wait for the second sale notice to happen within the next 15 days to do the auction where it will be at 75 rupees. He will not, where will be the value, where will you get a good realization of an asset? By such a regulation?
Right. Okay, good point. Because I think what is market mechanism and how markets operate need to be clarified. Though this is not the forum and this is not the place.
No, sir. I'm just looking at the regulation.
No. I am taking because your question relates to that. That's why I'm saying, though it is not the forum to clarify, but it is important to clarify because it is being misunderstood. See, the theory of market mechanism says that if certain thing has value and it has value in the eyes of more than one person, then they will bid and auction will always discover the best price. That is number one, is an assumption of economic theory. Okay. Proven across the world over centuries. Nothing wrong with that per se. You are talking of where there is only one serious bidder. Okay, possibly. Nobody else has come. Failed auction means nobody else has come at that earlier price. And it is possible that the reserve price was too high. See, what you are making an assumption here that the value as given by the valuer is the price that a willing buyer is willing to pay. It may not be. We know how valuations are done. What is the limitations under which valuers operate, the lack of information that they have, the lack of expertise they may have. Because you are a valuer for land and building doesn't mean that you know how to value every land and every building in the country. No, there might be other issues there, positive and negative. Okay, some buyer might know, okay, something else is going to come up here, some government announcement which has not yet come, he is aware of it, prior knowledge, he will bid more. And somebody who thinks, no, this is dump yard is going to come there tomorrow, the current price is too high, he will wait. So markets, the basic principle is markets might not be the most efficient way of doing things, but as of now, we do not know anything better than. Okay. So as of now, free market economy is the way to go, unless somebody comes up with much better system. Yeah.
Very, 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 very valid point. Why does a liquidator take time between two auctions? The reason is, he is not going to get any profits out of it. He is trying to maximize the value of the asset because he understands in the first sale notice, he gets only one buyer. He makes his sincere efforts to get more bidders in the second auction, even though the price is reduced at 10% or 25%, whatever the first time of auction is, second time auction is. It is not that he has his own limbs and fancies of doing things. This regulation is undermining the capability of a liquidator who is trying to do better things than anybody else.
Fair enough. Point taken. I think you can, definitely worth advisable that you specifically mention this and give it in writing that this is your thought process. I'm sure many people think that way. I think I started by saying that these proposals are actually, because they are actually on a sensitive issue, they are on the basis that liquidators are not doing their job. Okay, that is the basis of these two proposals to some extent. The board is going based on the data they have. That does not mean everybody is, when you make a, why should you make a law, CRPC kyun hai, IPC kyun hai? You can say nobody is a criminal, people are born free, they are all good, but you need a law. Okay, the law has to have certain things.
Sorry.
I am not the board, by the way, I am also IP only. Okay.
I don't understand
not make
that,
the mistake that I have anything to do with this regulation. I don't. I only made this PPT, nothing more.
Never, sir. I have high regards for you, sir. Don't worry.
No, I was just talking in a lighter way. Okay. Let's look to 11 and yeah, Mr. Arumugam, Boli.
Sir, the main problem is most of the times no lenders will give any money for that liquidation cost or even sometimes CRP cost also. And all the expenses are normally being met by the liquidator in from his pocket. And still you are insisting that number of actions should be increased. Then how to manage? And one point.
The question that you have raised,
Mr.
Remember, just so that we don't get off track, that is addressed in another discussion paper, which came later on. Okay. So I think that is a point that you should take up there because it has been specifically addressed. You know, creation of an escrow account, funding of CRP costs, etc. And the regulations as if today also talk of funding of liquidation costs. So both those things are there. See, you can make a law saying the horse should be taken to the water to drink, but you can't make the horse drink. So for that, if it doesn't do, you have to, there is only one way in democracies, and that is go to court. Nothing, there is no other way, right? So the law has been made that the members have to contribute to the fund, either for CRP cost or for liquidation cost. If they don't do it, that is a violation. So go to court, which is the NCLT. However, whatever they write in the law has to be enforced also. Huh? Yes, Shama.
Yeah, Raviji, what is the remedy available for consequent or I mean for series of failed auctions? Is it mentioned anything?
Remedy, not understood. Means
no,
auctions can fail.
Okay,
you can have 10 auctions
and
they all fail. That means there is something seriously wrong with one of the many things. One, the reserve prices are too high. Okay, it can be a very. Two, there can be things happening beyond what is within the knowledge and control of the liquidator and the which might be preventing buyers from bidding. These things can happen. Okay, criminal type of activities, I would say. Nothing much that you can do about it. Okay. Third is that there is really no taker for the asset. It is so specific and so what you call. That's why there is NRRA. This has been recognized by the board, and they have brought in a regulation for that. Okay, not readily realizable asset. So how to go about it? Even that nobody might want. Then, in such a situation, what do? Go to NCLT and seek direction.
Actually,
no law can provide for the 1 in a million case. That for that.
No. I'm not saying that. I'm just referring to a situation where in SARFAESI now they have brought a provision where they are talking of Swiss challenge, where eventually because of few failed auctions, the creditor talks to the intending participant and take an offer from them and eventually throws up in Swiss challenge on that. And
no,
that
is not prohibited in liquidation. Huh? That is not prohibited. In fact,
no, but this
liquidation process is so wide. Okay, unlike SARFAESI, which is specifically mentioned here, the manner of liquidation is left to the SEC. So, karo, Swiss challenge.
Okay.
No problem. See, as long as it is transparent, equitable, level playing field, and fair, any manner is okay.
Okay.
Yes, Sandeep ji.
Yes, auction is not only failing because there is no buyer. In my case, there is a lot of buyer, and the price has gone, I think, more than 3 times of the reserve price, and then the buyer doesn't take the property. We have to forfeit 3 times. It has happened like this.
Well, that is, I think I mentioned it indirectly because, we can't talk of this with personal knowledge, but there could be things happening beyond the boundaries of law, which you can't control. No? You might only suspect it, but who knows what's happening. So, exceptional case where 3 times you have successful buyers and they don't pay up. Very rare, very rare. But there must be a reason, underlying reason, very specific to your case. Okay, now we are talking about proposal 11, which is largely, I would say, okay, nothing very great about it. They are just saying that instead of any platform, now the IBBI itself has empaneled 2 specific auction platforms, NESL and M-Junction, and has left the door open to empanel further in future if people are interested. So only an empaneled PDA can be used for your auction process. So actually this helps because it standardizes the methodology, the platform, the costs of auction, and getting approval for that from the SEC would be that much easier. Okay, preparation of asset memorandum, great provision. I would say that don't wait. Nothing much changes between the closure of liquidation to start of, the closure of CRP to start of liquidation. So use the IM to make the AM. Then submit with 30 days. And now this was missing earlier. Now the AM can be shared with the members of the SEC on obtaining a confidentiality undertaking. Makes sense. I mean, they already have it by way of the IM. Nothing which we were hiding. See, it was like saying, okay, it is available on every platform, social media, but I will not give it to you because it is confidential. So something like that. So that is being taken care of. A welcome clarificatory amendment. Interim finance, again, a very positive step, which was preventing interim finance to be raised. Not that this was the only reason, but it was one reason why you couldn't avail interim finance during liquidation. Now interest is payable, not just for the 1-year period, which was there earlier, but till the amount is repaid. Treatment of avoidance application, coming out of experience in various judgments, etc. More specifically, Venus recruiters. Now, as it is proposed during CIRP, the same thing that SEC shall decide, okay, no longer discretionary. Manner in which proceedings in respect of avoidance transaction shall be pursued after closure of liquidation. That means you can complete the liquidation, file for dissolution because all the assets have got sold, but avoidance transaction proceedings are still pending. How they shall be pursued, who shall do it, how will it be funded, all that, it has to be decided by the SEC. And if any recoveries are made from that, the manner in which the proceeds shall be distributed. And this entire thing, this procedure of what is agreed in that SEC shall be part of the final report, which is filed before AA for seeking resolution. Any question here? Okay, so we come to the last proposal. Again, yeah, Mr. Vaidya, please go ahead. Mr. Vaidya.
With avoidance applications filed by RP, they are pending. So how this SEC will decide on that?
No, the SEC, okay. What is the SEC deciding? That after liquidation, okay, see, those filed by RP have to be pursued by liquidator. That's standard. Okay, there is no confusion there. Right. Now, after liquidator demits office, because liquidation is closed, who shall pursue it? Okay, who will fund it? How will the proceeds, if any, realized, be shared? Now, these 3 questions have to be answered by the SEC and form part of the final report of the liquidator when the application is made for closure.
But when the liquidator demits the office, then who will pursue? pursue that application.
That is to be decided by the SEC. It could be the same person, but not no longer as liquidator, but as Mr. So and so. They can designate. Yaap karo.
Can charge separate remuneration for that.
Yeah, it's a separate thing altogether. But no restriction is being placed in the regulation. Regulation says, yes, you decide because you are the beneficiaries. Isko paisa milna hai, they have to decide. No, they can't say you do my job, but I will not decide. Okay, Mr. Sen.
Yeah, it should be voted upon. I mean, mentioning in the proposal.
Everything in SEC is by voting.
Any decision, every decision.
Everything. 66% present and voting.
Okay.
Always. See, this will be like a resolution of the SEC, which shall form part of the final report. Yes, Praveen Bansal, बोलिए जी.
सर प्रॉब्लम जनरली जो कोर्ट में आती है वो ये आती है कंपनी क्लोज नहीं होती है तो दे डू नॉट डिस्पोज ऑफ एप्लीकेशन. So, do you think that this issue is being taken care of in this amendment?
No, when you say company close means samjhani, are you talking about strike off?
See, yes, because whenever we say
no, if your query is that can strike off happen and still avoidance applications can be pursued, the answer is yes.
That is,
yeah, because it was there in the earlier regime also. कोई नया नहीं है.
नहीं सर डिसोल्यूशन की बात हो रही है कि सर डिसोल्यूशन में तकलीफ आती है.
No, dissolution ends in strike off only. The words are different. They end in the same thing. The name is removed from the registrar, so the register of companies.
Okay.
So strike off can be through the winding up or liquidation route. Strike off can be for in another route. But ultimately, it is death certificate. आदमी छुरे से मरे या तीर से मरे या गन से मरे, मरना तो है ही. Manish ji, go ahead.
Good evening, sir. In one of my case of liquidation, avoidance transaction has been filed by erstwhile RP. When the matter comes to board, the respondent said that the liquidator have no power to pursue the matter because the liquidator has not filed any affidavit to continue the said application. But I am not finding any such law in the regulation.
Okay, yeah, you are asking a very, very specific legal advice for free, but ek baar ke liye bata denge. I was there in the hearing when you were talking about this, by the way, on that particular day.
Okay.
See, forget this IBC. What used to happen earlier when winding up hota tha? The liquidator would go and substitute himself in all the cases filed by or against the company, wherever. So avoidance application is also a legal proceeding. Liquidator has to go and get himself substituted specifically. It's just a simple application. Just make it. Yeah, see, other side will oppose. वो तो उनका काम कर रहे हैं ना जी.
Even the judge has agreed and he dismissed my the avoidance application.
Yeah, okay, procedural hai. If you want to pursue it, go to NCLAT.
Okay. Thank you, sir.
I can't tell beyond that, matter is sub judice. So
thank you very much.
Okay. Last one, as I said, welcome step again. And this was there in the regulation earlier. It was probably not clearly understood because of the language used, because the liquidation regulations talked of receiving claims during liquidation or updating. The word updating was there. And you can only update existing claims, not there. So that is now being clarified that if somebody doesn't file a claim during liquidation, but has filed in CIRP, that shall be considered by the liquidator. Simple gap filled up, nothing. Okay, so that completes our today's paper, and I think we are largely in time.
Raviji, is it other way also? That means somebody has not made a claim in liquidation
in CIRP and can file in liquidation? Absolutely. Absolutely. The two are in separate proceedings. Haji, Anilji.
This applicability of this regulation, as and when it will happen, they will be prospective or existing process also will be covered.
That depends on the wording that comes on the day the regulations are enacted and gazetted. So उसमें लिखा रहेगा कि is it could be parts may be retrospective, parts may be prospective. Some parts of it, like I mean, just telling you as an example, if it relates to the filing of reports, for example, liquidation, just tell you, that will be retrospective in the sense that all the old reports also they will give you a timeline. इतने में file करो जो अभी तक नहीं किया. Those who have already done, fine. See, the way we had CRP 1, 2, 3, 4, oh, LIQ 1, 2, 3, 4 आने वाला है. Yeah. And some of them which are irreversible or you cannot go back and change history, that will always be prospective. Okay. Yeah. I think that's it. So we have completed both. I will stop the sharing now, and any general comments anybody wants to make, please go ahead. Nitin, I presume you are noting down whatever is being said.
Yes, sir. I have noted.
There are quite a few comments in the chat box, but I have not been able to read. Please, anybody, if something has been missed, kindly.
Just wanted to thank you. That's all. Thank you very much, sir. It's wonderful. Yeah.
Raviji, that means IPE has to apply for AFA now.
IPE first has to enroll. Then any of their partners or directors who have not given the LIE has to give it, pass it, individually enroll. Then those they have to do the PREC, okay. Then the IPE will have to separately file for registration, okay. See, the word is registration. IPE as IP gets registered with the board. IPE only for support services gets recognized by the board. The two are totally different.
No, my point was that in case of AFA is given
AFA
to the
is
individual
I don't know how it will come. That part has not been there. I'm not aware.
Fine, it's not there.
Whether it is there, but I think there will be no such thing as an AFA for an IPE because the individual IP will have it, no?
Yeah. Second is what would be the future role of IPs as individual working? They will be there or some space reserved for them, or they will eventually disappear?
These are aspects of commercial aspects of in law. We will discuss it in the different forum. These are more appropriate for association of IPs, etc. Not so much for this platform. Because there will be an impact. There will be a significant impact. There's no doubt about that. There will be. Good, bad, ugly, we don't know.
Okay, thank you.
So the proposal of this thing is like a professional auditor firms की like उसी तरह से नहीं हो रहा है.
Accountancy firm, yeah, the structure to a significant extent is like an audit firm.
Yes, audit firm की तरह से ही कर रहे हैं सब.
Yeah, that's a model. There's no harm in picking up a model. Why reinvent the wheel every time? And I think RVEs, which are already functioning, even that has been mentioned in the paper, that this has already been tried there, and I believe successfully. So the same, instead of saying that it is being picked up from audit firms, it is probably more relevant to say that RVE is the model for making the new IPE as IP.
Okay. I think it will be published after the due period जो भी इन्होंने दिया उसके बाद ये publish हो जाएगा सर.
ये तो अभी enact होगा, regulations बनेंगे, and then they will be notified and gazetted. The usual process will be followed. When they will do, that is the discretion of the board. They will do it when they feel it is right. Obviously, first, by the last date for getting comments is 5th. I'm sure they will take a week or so to go through whatever has been suggested, factor in that which is relevant, and then do it. Maybe sometime in July, end of July, probably, we don't know.
Yes,
But that's their decision.
That's why it was published.
Okay, if there is no other question or comment, thank you all very much. I will hand over to Nitin. Right, take over.
Right, sir. So thank you very much. As always, I can see the chat box is full of appreciations. I mean, any session that you take, everybody feels enlightened. I would also like to thank the professional members for giving their suggestions. We have noted it down, and in line with our commitment, we shall keep organizing such roundtable discussions, and we expect your presence there also. Also, in case any of you want to make an additional suggestion through a mail, you can send it to me at, I'll provide my email ID in the chat box itself. Right. So, sir, thank you very much. Participants, thank you very much.
Thank you.
Thank you all, everybody. Bye-bye. See you next time whenever we meet. Okay.
Okay, so thank you very much.